All right, so let's just go over this, guys. Representation. Oh, sorry, we got to go to point 1. Okay, again, remember to review this about the ways to study, that kind of stuff, preparing for and taking the IRS enrolled exam. This stuff is good stuff for you guys to read. Okay, so let's go. What are we talking about? The first is going to be authority to practice. Who can practice in front of the IRS? Okay, so it's going to be lawyers, CPAs, and enrolled agents. On top of that, enrolled actuaries can practice. Is that the right wording? Enrolled actuaries and enrolled in retirement plan agents. But actuaries and retirement plan agents can only do their special fields. Think of the 5500 series of tax returns, okay, which is only for pension plans. I used to have to do one for my own pension plan once upon a time. It wasn't hard until we got over a certain amount and we had a number of people in the plan and they didn't want to act right. One person wanted to do one thing, another person wanted to do another, and a third person. So one guy wanted his money. We put the money in and he didn't want to take it out. Okay. But that doesn't affect us. Okay, so who may practice? What is a practitioner? Those are the people that can practice in front of the IRS. Attorneys, CPAs, and enrolled agents. There's annual filing season program participants. They call that the AFSP. I've known this number for years. The IRS tried to get me to teach these classes and I'm just not gonna. It's like enrolled agent light, so to speak. Anyway, IRS would like everybody to pass tests every year to be tax preparers. The Enrolled Agent Society also wants to do that. NATP is more neutral on it. But what they want is everybody to take classes. Why? Because then NATP, NAEA, the CPAs, everybody gets to give classes and they get to charge money. They make money, which is, I might be cynical to say that, but they also want to get rid of the bad people. Just today, one of my clients came back. He came back just to call the IRS because they haven't started his installment agreement because we sent in a letter about this disreputable tax preparer. Somebody did his tax. Well, first of all, this guy's dumber than dirt. He comes in and goes, well, one of my friends told me about this tax preparer, and so I met him out at a Starbucks out in Cujillo and gave him $400 in my paperwork and never saw him again. He filed a tax return, got this guy a lot of money, but he would never meet him again. Wouldn't give him his paperwork, didn't give him the file, and turns out he had filed a tax return, made up a whole Schedule C, which the guy didn't do, and gave him a loss of $25,000, $35,000. Got the guy a big refund when he should have owed money. If he'd have done it, he might have owed $1,000 if he'd done it correctly. He didn't have enough money taken out. But the IRS caught him, and that's how he came to me. And he goes, well, the friend of mine that told him to go there, he'd done 3 years with this guy. So the IRS audited him, caught him, and he owes him 3 times as much money. And so, anyway, we wrote there's a form that we're going to go over in here. You write up, explain what happened. The reason we're doing this is to get this gentleman out of all of his penalties for doing a disreputable, he's in the top of the penalty list, really, for filing a fraudulent tax return. It could be 75% of everything he got. So he could be in a lot of trouble. Okay, so let's get going on all this before I forget that we're here to actually learn this. So, okay, the rules governing practice for the Internal Revenue Service, they appear in the Treasury Department Circular 230. Ah, and I got one handy here, which I forgot to bring in.
Oh. Right.
Okay, Circular 230, it's a lot of pages. I personally have read this thing through about 3 or 4 times. I suggest you guys do it, but it's a lot of the same things that are in there are in here. But by reading it through this one, it's dry, but it's the real thing. This is our little Bible in effect. Okay, who has to follow Circular 230? Lawyers, CPAs, and enrolled agents. We've got to follow this. If you're just a regular tax preparer, do you have to follow it? Not really, not so much. But we do. Okay, practice for the IRS is the presentation to the IRS or any of its officers, any matter relating to the taxpayer's rights, privilege, liability. It includes communicating with the IRS, representing a taxpayer at conferences, hearings, preparing necessary documents, rendering written advice. That's gonna be, you need to know that because they're gonna ask you a question. What is practice for the IRS include? It does not include preparing tax returns, furnishing information, appearing as a witness. That's also gonna be a question. Every year forever they've asked those two. Because it's kind of simple. And the real thing is, doing a tax return is not practicing for the IRS. Furnishing information. You're a friend of somebody that did a tax return, and the guy has a hard time speaking English, and you're sitting with him, and the IRS asks what's going on, and you go, here, let me help you, let me send you, there's nothing wrong. That's not practice for the IRS. Okay? They're the word practitioners. That's what we are. Attorneys, CPAs, enrolled agents. You also got enrolled actuaries, retirement agent plan guys. Those last two aren't going to really be on this test. They may be one question, but that's not going to be on here.
They're unenrolled individuals and appraisers?
Okay, what are unenrolled individuals? We're getting ready to go there. But annual filing season program participants, they're going to hit you with a couple questions. What are those guys? It's anybody that wants to take the test that goes with this. And if you're an annual filing season program participant, that means you go and you study, you pass this test, and it doesn't make you a practitioner, but it means you get to do certain things. It means where an enrolled agent CPA, we can represent anybody, anytime, anywhere, for any part of the IRS. So if it's an examination, if it's collections, anything, we can represent them. Okay? So for these other guys that are the annual filing season guys, AFSPs, they can only represent someone before the IRS in the examination phase. Okay, not in collections, not in appeals, not in anything else. They can only do examination. So, also they can only represent people where they did the tax return. So, they have to have done the tax return and passed the test in that year. So, if you're an AFSP for 2015, and you prepared the 2015 tax return, you can represent that person in the exam portion. Okay? Now, if you want to represent them for their 16, but you didn't prepare their 16, or you didn't go take the AFSP test again, you can't represent them for 16 or 17 or 18.
So they have to take the test every year?
Every year, yeah.
And how many changes are there
And
normally
it's-
in the tax system?
It depends. In 2018, there were more than we've had in years. This is the biggest tax change since 1986. And it's, they're just finding out that a few of the problems that they didn't realize. By the way, does everybody know that this next year, you know how they changed the page 1
Yes.
this year was really page 1 and
Yeah.
2? They're going back.
Oh, good.
Yay.
There's still going to be a few changes,
Right.
but they go, that didn't work out so well.
No.
But the Republican that did the tax overhaul wanted to say it's as small as a postcard. So you could take the front and the back and make it into a postcard. They didn't say that they added a whole lot of schedules, and so that only a 1040 EZ could be a postcard.
Right.
Okay. So you're going to have to know about the AFSPs. They're going to ask you. The IRS really likes this. They want to make it so every preparer has to be at least that level. They can't do that unless Congress passes a law saying that. Right now, they can't even pass a law, Congress hasn't passed a law saying that they can regulate preparers. They can't even charge preparers to get a P10. By the way, our P10s are going to be coming out starting in the next couple of weeks. All you guys that have P10s, you need to get them. Lynn, sometime in the next couple of weeks, after October 15th, I will help you get a P10. It's free, but it's mandatory. Or you turn into a pumpkin right at Halloween.
And what is a P10 exactly?
It's, instead of using your Social Security number on a tax return when you file it, you have to have a P10 and you have to put that number on there. Instead of requesting to take this test, you have to have the P10 and you have to give it to them. And it's, think of it as your Social Security number for paid preparers. The reason is, we all used to, forever and ever, up until 10 years ago, we had to put our Social Security numbers on every tax return that we filed. And that means if we filed a tax return for a Russian spy, he got a copy of our Social Security number. And actually, I think maybe the Chinese spy, they just arrested somebody yesterday on the West Coast. Okay, so let's crank them up. Here's, it says, who can practice unlimited attorney, CPA, EA? What can they do? Pretty much anything. Who's limited? The AFSP, this is what we've been talking about. They can only go between what they call revenue agents. A revenue agent and exams are the same. They can do it only exams only. Returns that they've signed.
And it's a 6.
And they must participate in the AFSP or be specifically permitted to practice. Okay, real quick, we're going to go over what are the guys that are unenrolled individuals other than the AFSPs. Okay, anybody can prepare your own tax return. Anybody can go through any portion of the IRS, not just examination, appeals, collections, any part of the IRS. I can do it for my own tax return. Even if I'm a bank robber or murderer or anything, for me, okay? Who else? Anybody, if I have a company, any of my employees that work for me as a full-time employee they could do it. If I were to have a corporation, any of my corporate people can file tax returns for me. Okay, and they're not really considered tax preparers. If I'm a fiduciary for a trust, I can file the tax return for that trust. I'm not considered a tax preparer in that sense. Why is that important? They can't give me penalties for messing up the tax return. If I'm a tax preparer for VITA, I'm not really a tax preparer. If I do my mom and pop's tax return for free, I'm not really a tax preparer. Everybody kind of got the general idea? All right. So, what's an enrolled agent? That's what we're really about. Is they're recognized as a practice for the IRS. They have to present satisfactory identification. Lawyers and CPAs go through a little different process. It's in your, just read, if you've read the chapter, no problem. Mm-hmm. Only natural persons can be enrolled agents. Mitt Romney, back when he was running against President Obama, said corporations are people too. Not really true. In his own mind they were, but that didn't serve him so well when he said that. Okay, so only natural people. So a corporation can't be an enrolled agent. A partnership, corporation, sole proprietor. So attorneys and CPAs can be enrolled agents, but they don't have to be. They still, okay. Eligible to become enrolled, you got to have conduct. You can't be suspicious. What is the conduct? Okay, you got to have good conduct. You have to pass the exam or IRS experience. So, to be an enrolled agent, you guys got to pass these 3 exams, and that's really the reason you guys are here. Some of the people that were here, I think Bay was one of them. He only came to part 1 because he just wanted to learn this stuff.
The one that was sitting back here.
Yeah. He's been with me longer than any other of my employees, say 25 years.
Wow.
And he could be semi-retired. He does this because he likes to. Okay, and I don't know if anybody else is doing that. It's hard to say. The guy that was up here was doing that. He may have given up. It might have been a little too difficult for him. Okay. So eligibility, you gotta have, you gotta pass a. I think they give you a fingerprint maybe and make you pass some kind of test. They check to make sure you filed all your tax returns. You're not an axe murderer, although you might be able to be an axe murderer. What you can't do is have a conviction of any of the tax laws or anything that has to do with theft. I think murder is okay. Just don't steal. Look at your fellow people around you. Okay, and you got to have good content. You got to pass the exam. Application to become an enrolled agent. You guys, you need to read this. I already know most of this because it hasn't changed in so long. So it's hard to tell me. But you're gonna know it for the test, know it when you sign up, and after that you can forget it.
Thank you.
Okay. Properly executed application for enrollment is necessary. If for some reason the IRS turns you down, you got 30 days after the receipt of the notice to write them a letter and go, what's wrong? That kind of stuff, you're not very likely, but you need to read it, just know it for the test. Eligibility of non-Form 1040 series preparers, that would be like your actuaries, and your pension plan guys. Okay, so eligibility non-form 1040 series preparers to represent clients. We're not going to go over other persons who may represent. Okay, this is what I was talking about. You need to know this. Other persons who may represent practice before the IRS on a limited basis. Anybody can represent their immediate family, brother, sister, father, mother, your kids. An employee can represent if he's a full-time employee. A partner, general partner, can represent the partnership. An officer or a regular full-time corporate employee can represent the corporation. Fiduciary can, as a trustee, can represent them. Overseas, an individual may provide representation to any individual or entitled if the representation takes place out the United States. So if it's overseas, other individual, this doesn't happen much, but you need to know it. Any individual may be authorized by the Commissioner of the IRS to represent another. That doesn't happen in real life, but you probably might need to know it for the test. Any practitioner who for compensation prepares and assists in a tax return is subject to the rules of Circular 230. This is Circular 230. It's what we really go by, and that's what these chapters are really about, is really they're just redoing what's in Chapter 230. Who may not practice? A member of Congress may not practice before the IRS if he was doing anything, he had anything to do with passing a law, and that that directly or indirectly has anything to do with what the tax return. An officer or employee of the U.S., that would be legislative, executive, judicial branch, or representatives of the immediate family member. Okay, just all you can do is, I'm just reading this stuff to you. The state employee who investigates, a state employee who investigates, passes on, or otherwise deals with state tax matters may not practice before the IRS. An individual convicted of an offense involving dishonesty and breach of trust, where you can't get caught stealing from your clients, you can be an axe murderer. Just saying, that's the way it's written. Okay. Okay. Oversight of practice. Who's in charge of oversight? The Commissioner of Internal Revenue or their delegates. And you need to know these A, B, or C's. We've already just talked about PINs. Everybody except maybe Lynn is familiar with PTS. You all got them, right? Okay. They must be renewed annually, and it's going to start again in 2 weeks. And probably some of us, I was lucky enough last year, they picked me out for some reason, and they gave me an email. Anybody that gets the email, you just go poof, and you're done, you're signed up. So a bunch of you guys may get them, depends on how long you've been around. Okay, conduct of practice. The rules for conduct is in the Circular 230. A person representing a taxpayer must be qualified. We're going to get into it later, but you get caught pretending to be an enrolled agent when you're really not. You're not going to ever get to be an enrolled agent again, probably. Okay. A person representing a taxpayer before the IRS must be qualified. The duty may not be delegated to an employee of the qualified. So I cannot delegate to my employees all the things to be an enrolled agent. So I can't have my employees, except for Sam, who's an enrolled agent, call up the IRS on my priority hotline and say they're mean, or give them my CAF number or some such. That would be a big no-no, and I would probably be thrown out of business. Okay? And to do any kind of written authorization, we have to have a power of attorney. We're going to go that in a later chapter. It's called 2848. It's a power of attorney. We have to say who we are, give our name, address, social security number, P10 number, CAF number, and we got to say who the person is, their address, their social security number, their phone number, and we got to say what do we want to do for that person. I want to represent them on income tax returns. What kind of income tax returns? 1040s. What years? I want to represent them for 2015, 16, 17, and 18. I suggest if you're right now, you would add in 19 just in case. Question?
It's interesting because when you fill that form out, okay,
2848.
yeah, or the 8821 for me.
Okay.
Okay. I called them and I got everything done, right? But on the form, you have to put the title of the individual or the client, okay?
The title.
Yeah, and they refused to,
Like member or
oh,
owner?
yeah,
Member, if it's let's just say it's an S corporation LLC, then you have to be a member.
right, okay.
If you're a partnership, you'd have to be a partnership.
Right.
If you're an individual, you don't have to put individual. I never have.
Right, but they didn't, allow me to,
Because you didn't put that in there?
Right.
What did they say? Did you say, can I get this, put this in there, and then resend it?
She didn't answer.
Huh?
They didn't answer. They
I
said,
don't believe.
It's incomplete.
Okay.
That's all they said.
Okay. Then, I would, do you, every time you talk to somebody from the IRS, you know how they give you the name and number, and they rattle it off so fast you can't understand them? Stop. Go, excuse me. Well, I'm ready, and I usually can get the name and the number.
Right.
If the name is too exotic, I may not get it, but I'll be sure. Every one of their numbers always starts off with 100 or 1,000. So you go, I'll put that 100 down and just try to keep up with them. Then I go, excuse me, let me double check. Is your number 100, 1, 2, 3, 4, 5, 6, 7, 8, 9? And is your name Mrs. Blage, or is it Mrs. Bolton? And how do you spell it? There's a real reason why you do this. Because by writing this down, getting their name right, if they then act like a jerk, you've got their name, their number, and you can take it to possibly the taxpayer's advocate office. In my case, I take it to the stakeholder liaison. I haven't really gotten anything done, but 3 or 4 times in my life, I've actually gone as far as how do I write this up on this lady?
That bad.
Huh?
That bad.
Sometimes they're not really that nice. Most of the time they are. I got one today that she was trying to tell me that the client can't give permission for me to talk to her. And she said that the first time I let it put him on there. Then she put us on hold for 10 minutes and I got the phone and I waited. And I go, and so before I gave it back, I went over this again. You're saying, and she came off of it that time. She says, okay. So she let him give permission for me to talk. She went through the whole verification with me. But I'm talking with these guys almost every day this time of year. And if you, first rule, you be as nice as you can. Second rule, you make sure you get it, and then you, while you're being polite, you make sure that they follow the rules themselves. Because they will push you around if they think they can. Okay, sorry to get carried away. That's probably not part of this. Okay, conduct of practice, relying on information furnished by the client. Can we rely on information furnished by the client? Yes. But does that mean that we must make reasonable inquiries? However, the parent, you cannot ignore the implications of the information. That's also a guaranteed test question.
Where are you at? What number?
I'm on page 12, Conduct of practice, relying on information furnished by client. Just down from where I was. Okay, and the third one is preparer should make appropriate inquiries of the taxpayer about the existence of documents for deductions. The biggest one right now is due diligence for your kids. We have to require, are your kids U.S. citizens? Do you have a copy of their Social Security card? You got a copy of a birth certificate? What proof have you got that that child actually lived with you? Okay. When I was in Vegas, one of the lady speakers tried to say that this is what she does in her practice. She won't do a tax return unless they come in with Social Security cards, birth certificates, and proof of residency. And I asked her, what do you do? Well, this was a little different. I asked her, what do you do if somebody has a Schedule C, but they don't have any written records? They were a landscaper. They're just someone that's not English as a second language. They don't have any documentation. I throw them out of my office was her answer. I took that to another speaker and told someone that I knew and explained that that was not realistic. For her job, in her kind of place in Missouri, or no, she was from Ohio. In Ohio, maybe she could be that way. Or maybe her clientele, or because she wrote the book on best practices, that's the way she runs her business. That's fine, but that's not the law. The law is you have to ask questions. The law is you have to say, do you have your Social Security card? Do you have your birth certificate? Do you have proof that your child lived with you? Such as what? School records, rental contract, something from the doctor, if you guys are church-going people, something from your minister, these things. Now, if they walk into your office and they go, I don't have all those, I live in Waianae, it's really an imposition for me to go get all that, but I can get it if the IRS, and then you go, I asked, this is what, can you get me this information if the IRS asks for it? And then you document. You have to ask the questions, and by law, you have to document what they say. And they said, and I actually have, what do you call it, a macro? You know, where you can push a couple keys and it writes out the whole sentences? I have it so there it goes. I asked, and the taxpayer said, these were his kids, and then kid and kids in parentheses. Then, and he said the children live with him, and he could get the proof if the IRS asked for it. So that I try to do that on every person. If they come in with the Social Security card and the birth certificate, by law, you have to make a copy. If by law they come in and they say, no, I'm not going to let you make a copy of my Social Security card, you might be a Russian spy. Then you don't make a copy, but you go, they showed me their cards, they wouldn't let me make a copy, and you've written it down. Okay. So you can rely on information. Conflict of interest. What happens if we have a conflict of interest? Okay? If you have a conflict of interest, you got a married couple that are getting a divorce, or they just got a divorce, and you know them both real well, and there's not really any problems, and you have them both come in, they both have to give you in writing saying, I have no problem with you doing both of our tax returns. You have to also believe that you can do both of their tax returns and there's no conflict of interest. What is the third one? You must have written consent within 30 days. It's not prohibited by law. You can really believe that you can provide the competent and diligent representation to both clients. Okay. There's a bunch of other ones. Then diligence. Diligence must be exercised in preparing and assisting in preparing, approving, and filing regular documents and other papers. So, what does that mean? You, as a taxpayer, has to use due diligence. You have to ask reasonable questions. If you ask somebody, okay, you have your two kids, you live together, you and your two kids, where do you live? And they give you an address here in Kalihi, and go, oh, where do your kids go to school? Out in Waianae. You better ask some more questions real quick. But you gotta go, wait a minute, how do you get your kids from here to Waianae? Or just the other way. They live here in Kalihi, but their kids go to Kahala Elementary. Okay, and then you go, how's that happen? We have a district exemptions. We're telling the school that they're living with my mom or grandmom. They're lying. But that is what you have to write down. And they go, I don't want you to write that down. Whoa. That's the and that happens, by the way. We have that happen a lot, don't we? So, but what you gotta ask, and that kind of stuff. Why? Let's just say that a lot of times you have unmarried couples. One person lives here, one person lives there. The kids he's saying, these are my kids, they're living with me. They're two 6 and 8 year old kids. I'm a construction worker, and they go to school in Eva. You probably shouldn't let that fly. You go, how do you get them to Eva every day for school? My girlfriend takes them. Where does she live? Eva. All right. Assistance from a suspended or disbarred person. This is on 14. This is a big deal. They're going to ask you. You cannot give assistance to somebody that gets suspended. You have an enrolled agent. He's a great taxpayer. He got suspended for cheating and lying, and you hire that guy, you can be thrown out of business. Here's the one that's even trickier. You work for somebody. You're an enrolled agent, and you find out that, oh man, my boss just got suspended. What do you do? The only correct answer is you gotta quit. You cannot work for him, legally, period. Whether he's doing anything wrong now or you can't work for him. And you can't go, I didn't know. Well, you might. Good luck with that. Okay. What happens if you have a client that you're doing his tax return for 2018, and while you're doing it, you have no problem with it, but you notice that he forgot to put some income down on his 17 tax return. What do you got to do? No. The answer is you have to inform him that your 17 may have a problem, and these are the penalties that could occur. You don't have to tell the IRS. You don't have to quit doing his 2018 tax return. You don't have to make him file his 17 correctly. You just got to tell him. That's a for sure question. That's been on every test forever, and it probably always will. That's a big deal for you guys. Okay? So what happens if that 17 information affects his 18? You've got to do the 18 correctly. And if he goes, well, you can't do that, then they'll know that I cheated. Too bad. You can either, then you can you just walk away. Or whatever you want to do. But you can't, if the 17 doesn't affect the 18, you just got to tell him. If it affects the 18, you got to do the 18 correctly. Okay, and that is a big deal. Here's another one. Return of client's records. You ever had this happen? Client comes in, you do their tax return, and they go, oh, that's the same answer I would have gotten from TurboTax. And they go, give me back my records. And you go, I know you owe me money. You have to give him back his records, period. But you don't have to give him anything you've done. All you have to do is give him his W-2s. He goes, but blah, blah, blah. I've got a little sign up there that says, we have a $25 fee or some fee for us doing this. But I also know that if push comes to shove, we just give them back their records. We say, though, by the way, we point to that sign, you owe, oh, there's another one right there. Okay, so you owe us. But can we keep their records? No. A practitioner may not charge an unconscionable fee. Yes, ma'am.
Can we keep their records? I mean, the 1040 say that you prepared.
You only give them back what they brought in. They didn't bring in the 1040. See, you give them back just their W-2s. Can you keep a copy of everything they brought in? Yeah. Yes. And I've had them go, no, I want those copies. No. I had a guy go berserk on me once over that. And he went on something and started going, these rotten guys, they kept copies of my stuff and I wanted everything back. And they go, we're going to tell the IRS. I go, here's criminal investigation. I went and got the criminal investigation number. This is the head of criminal investigation in the state of Hawaii. Here's his number. Give him a call. Good luck with that. But I gave him back his W-2s. He wanted me to delete his information out of my computer. You can't do that. Okay, advertising. Okay, you can say, you can use the phrases enrolled to practice before the IRS, enrolled to represent taxpayers before the IRS, admitted to practice. What you can never say is the word certified. You can never say, I'm certified to practice. Only people that are certified public accountants. And they guard that a lot. If they catch you doing that, they will get you. Actually, nothing will happen the first time. You'll just be told don't do it again. Radio and TV must be pre-recorded. These are questions you may get. A recording must be retained. How long? For 3 years. Mail solicitation. Designed for the general public is permissible. Mail solicitation for non-tax return services based on specific tax return circumstances is not permissible. I do tax returns for a bunch of people, and I see, oh, look at this, and I get a list off my, I got 500 people here could use IRAs, and I can sell IRAs, and so I send those 500 people a letter going, hey, would you like an IRA? And you're in trouble. H&R Block got in trouble about that several years ago, and they finally had to stop. Here's what they were doing. They had that exact same thing, and they were going, and while you're doing the tax return, you can say you need an IRA. No problem. You just can't send them the letter later on. But what you can't do is try to sell them an IRA. They cash that IRA in the next year. You've not done the correct service. You've actually talked them into buying an IRA they didn't really need. And so H&R Block got a big fine for doing that. They quit doing it since then, I think. I don't know for sure. A practitioner may not assist or accept assistance from any person or entity that the practitioner knows has obtained clients in violation of Circular 230. So, you have a friend that's not a tax preparer, but he knows a lot of people in his community. We had a gentleman living out in Nanakuli that was doing tax returns out there for the Samoan community. And basically they were passing kids around like dealing cards. This was 15, 20 years ago. And the guy got in a bunch of trouble, and they had to go rent several schools in several parts of the town and have all the people from that community go in there and go, you can't give away your kids to other people. So if you have 5 or 6 kids, you take 3 and you give 3 to your brother or your sister or somebody. Wrong answer. And what they were also doing is married people. You got 6 kids, I'm head of household, you're head of household. This guy was doing that and he got in trouble. He went to jail. He also, more dangerous, he almost got killed. You notice that several Samoan guys are big. Well, he's a pretty good sized guy, but he's maybe 220, 6 foot 220. That's tiny in that world. And there were guys looking, because they filed 3 years and got these big old refunds, and then all of a sudden they got letters, they got in a bunch of trouble, and they were mad. Now, he's passed away since then. His name was Scotty. That's not much of a Samoan name, but he was a Samoan named Scotty. Okay.
So are you limited to 3 taking,
No. You're supposed to take your kids. You're not supposed to take, I'll take these 3 because that's the maximum for earned income credit. That's where they got the most money. So, and then I have another relative, they might all live in the same household, or they might not. And I go, well, my brother over here, he's not married. He doesn't have any kids. Let him borrow 3 of the kids. And then if you have 9, then you got another brother or sister or mother or some other relative. Yeah, it was fast and loose. This was at 10, 20, closer to 20 years ago. That has not happening in that community so much. The newest community is the Micronesian community, because they came and they don't understand our laws, and somebody tells them, oh, you can do this. And they are slowly but surely figuring out that they're getting in trouble. Okay, best practices. These are the things you should do. I'm not gonna, all I can do is read them to you. Supervisory, but you need to read them. These are the things you need to perform, the steps necessary to support the facts of tax. Just read them. I can't do anything.
Oh, you're page 18?
Well, 16 in my book. But I'll be.
Oh, okay.
Okay, supervisory responsibility. What does that mean? Okay, I own a firm. I have 20-something preparers. I have to educate my preparers to the rules, or I can be responsible for the same penalties that they get. So my preparers, I have a preparer that doesn't follow due diligence on earned income credit. For 2018, the fine was $520. That's what you got to know. For 19, it's going to be $530. You remember 520, but it's getting ready to go up $10. So what does that mean? If I don't use due diligence on earned income credit, child tax credit, head of household, or American Opportunities Education credit, there's 4 credits. I could have a $520 fine for each of those credits. So if I did not do due diligence, and let's say that they came in and they gave me a couple of Social Security cards that says, yeah, these are my kids, they live with me, and I just put them on the tax return, typed away, and go, great, you get an $8,000 refund. And I don't make notes going, I asked, they said they live with them, what school do they go to? They said they go to Farrington High School, and then come to find out they're going to school out in Eva Beach and living with their mom and not living with this guy at all, and he's just trying to cheat. I didn't ask any questions. I didn't do anything. I'm subject to that fine. So that would have last year, that would have been $2,080. 4 times, okay, so $2,000 fine on one tax return. What's worse is if the owner of the firm didn't train and supervise his employee, I am also liable for that $2,080 fine. So for that one tax return, the IRS just got $4,000.
So if he's paying child support for these children, that they're not living under his, he still can't?
Nope. Where that is one of the rules to be a dependent, to be a qualified child. First rule, what? Son, daughter, brother, sister, or their descendants. That includes half brother, half sister, step brother, step sister. Everybody's good with that. Second rule, what? They have to be under age 19, under age 24, and a full-time student. And both of those have to be younger than you, or they have to be totally and permanently disabled. So, they have to be younger than you and under age 19 or under age 24, younger than you and a full-time student. Third, they gotta live with you in your household for more than half the year. The exceptions would be if they're away at college or they're away at reform school. But I've never had that one. I hope I don't get it. But anyway, so you've got to ask, did this child live with you? And you can't, if he just goes yes, and you accept that, he said he lived with me, you may be in violation of the law if he says anything different. If you just don't ask your head questions and put your head in the sand, this could not go well for the owner of the business. So, I personally believe there's something called the EITC toolkit. It's on the IRS website. You can put it on there. If you've got employees, you need to go over the rules for earned income credit with your employees every year. Document that you went over it with them and put that in their records and your records and keep it. So, if they go into the IRS toolkit, there's a little thing that you see, a little video about earned income credit. At the end, you take a test, and after you take that test, if you pass it, you get a certificate. You hand that to your employee, he puts that in your employment records. Then, if the IRS goes, you let this idiot get away. No, I didn't. And you have a document that you went over and talked to all your employees. What you talked to them about, they took the test, you told them to do this. I actually sent a certified letter to one of my employees today saying that she had told me we checked at the end of this tax season and she had not done her due diligence. So, and she goes, I will come in and I'll fix it. Now we're at the end of summer. She hadn't come in, and she could be liable for let's see if that she could be liable for $40,000. I believe I'll get a phone call. By the way, I sent it certified mail. And in a couple of days, I'm going to actually call and go, hi, I sent you a certified letter. You told me you were going to come back in and fix all that. You didn't do it. You need to document all your tax returns or you could possibly be in trouble. If the IRS, nothing happens, the IRS doesn't ever come and do anything about it, Okay, no harm, no foul. But if they do, I don't want to be the guy to get caught with a $40,000 fine. It's okay for her to have it, but not really. We don't really want to have to deal with that. Okay. So, what happens? A practitioner does not take responsible steps to ensure that the firm has adequate procedures to comply with the Circular 230s. So I have to have procedures. And should know that a pattern or practice of non-compliance. No, practitioner is liable for such action if it is willful, reckless, and grossly incompetent. We don't want to do that kind of stuff, right, guys? Okay. Requirement for written advice. I'm just going to let you guys read that based on advice of reasonable assumptions. Reasonable, considered all relevant facts. I can't tell you anything about that. Sanctions and disciplinary proceedings. Okay, here for the rest of this chapter, there's a lot of this stuff. It's going to be real fast, but I'm going to. Okay, sanctions. There's three kinds. What are these? Censure, suspension, disbarment. Censure, the IRS slaps you on the hand. A censure is they just publicly reprimand you, saying tax preparer Bobby Jones has been doing a bad job. Don't do it anymore, or we're going to get you. They also, with censure, will go for the rest of your tax returns. If you're doing Schedule C's, we want to make sure you document that they have their mileage log, that they have their receipts. So what happens if one of the things that I came back from, if you've got somebody with earned income credit and they don't have a mileage log, that's a $525 fine right there. You can't, and I'm going to find out from the IRS soon whether I can actually do the tax return. If they don't have a mileage log.
For earned income credit? Mileage log?
You're a Schedule C business. Oh. You're running your own business. Mm-hmm. Okay? You don't need a mileage log if you're an employee anymore. You can't write it off. Mm-hmm. Or at least some of it. So, but if you're a Schedule C employee, you can use a mileage log to put yourself in the sweet spot. Do you understand what I mean, sweet spot for earned income credit? Mm-hmm. There's between about 8,000 or 9,000 and 15,000. You get the maximum amount with your kids. So, and you can, it's just as illegal for someone to not count their expenses so it doesn't bring them down too low as it is to exaggerate their expenses so that their income goes down. You ever had somebody say, just never mind, leave those expenses off? You can't do that. Right? So what happens? In your case, it's a $520 fine for just doing that. So you can say, oh, well, my client's not going to tell on me. Wrong. He gets caught by the IRS and they start hitting him with, my preparer made me do it. I didn't want to cheat. My preparer made me do it. I'm exaggerating, but not so much. Okay, so sanctions. First, the Secretary of Treasurer may censure. So it's really the Secretary of Treasurer or somebody under him. Okay, the following is a brief list of incompetence and disreputable conduct. So what can they do this for? If incompetence or disreputable conduct, refusing to comply with the rules and regulations, willful or knowingly with intent to defraud, deceive, or mislead, or threatens any client. Any of these things, boom, you can be censured, suspended. So censured is just a slap on the wrist. You can still practice. Suspended, you're suspended for a year, 2 years, 3 years. That means you can't practice in front of the IRS for those years. Disbarred, you can't ever practice again until you get approval to go back into practice. And you need to know this, 5 years. You have to wait 5 years after disbarment to go back into practice. If it's suspension, at the end of your suspension, let's just say 2 years, you can go back into practice. Okay, so here we go. What's a list? The following is a brief list of incompetence and disreputable conduct. Here's one of the key questions. They're going to give you this list. There's a whole lot of them. You just got to look at it and read them. The list on the first one goes all the way to R. One of the catches is, it says on here, if you're convicted of any criminal offense under a federal tax law, which is, again, you can murder somebody, you just can't be caught under tax law. Okay? Any criminal offense for dishonesty, you're okay. Conviction of a felony under federal state law for which a conduct involves renders a practitioner unfit to practice. The murder might get you right there. They might use that one. Other than that, you can murder somebody, you just can't steal from them. Okay, the key on the question that they're going to put in the test, it's not going to say conviction, it's going to say, they're going to be indicted. Indicted doesn't matter. You have to be convicted. So they've got a trick question in there that I remembered from years ago. Solicitation of employment is prohibited. You can't use false or misrelating things. I can't say, I'm best friends with the head of the IRS. You come to me, you'll be okay. I'll get you a lot better deal. I'll get you a better refund. That's a big no-no. So there's a whole list. Willful disclosing or using tax information for anything other than a tax return? No, you can't do that. You can't, if you do a tax return without a P10, nah, you can't do that. You're going to be disbarred. Anything that you do with the intention to evade federal taxes is illegal. So don't. Okay. Then over here, the next one, they got Circular 230, list of conduct that results in suspension. It's another list, the same thing. Being convicted of dishonesty or breach of trust. The key word is convicted. Circulating or publishing matter related to the practice for the IRS deems libelous, malicious, using abusive language. You cannot cuss out an IRS agent. You cannot threaten to bash their head in. Even if she calls football on Serena Williams. Lynn knows. Okay. There was a famous umpire, one of the best in the world, 5 or 10 years ago. Serena Williams was called for football. Serena Williams went over there and told her she would like to stuff that ball down her throat. This little girl was like smaller than you, 5 foot tall, little Japanese girl, but she was ranked as the #2 referee in the nation. She was really, really good. And so she just calmly went to the chair and go, chair, Serena Williams just threatened to stuff a ball down my throat. And the chair goes, code violation. Serena Williams blows up and goes, I've never committed a foot fault in my life. She's making all this up. Blah, blah, blah. Well, then they re-showed the whole thing, and Serena Williams. And all the umpires in the nation were mad at Serena Williams for a while. That was in the U.S. Open. One of them she lost. Okay. Here's another one that you might watch out for. Failing to electronically file when required to do so. Okay, so here we go. How do we have a complaint? So you do something the IRS thinks is wrong. First, they have to have a complaint. What do? they have to start a process. The complaint should contain they have to file a complaint and mail it to you. It should be clear and concise statement of the allegations that constitute the basis for the proceedings.
Who's gonna file, the client?
Usually it's the IRS.
Oh, the IRS.
Against the tax preparer.
Okay.
They're gonna send it to you, and they're gonna say, you call me an SOB. That's not nice. And this is our complaint. They gotta say, you use bad language, blah, 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 in violation of Circular 230. Okay? It is sufficient if fairly informs the respondent of the charges such that they can prepare a defense. You can't just say, you said some nasty things to me. You gotta say, you said whatever, and that's not okay. Or you cheated on your on that guy's tax return. You said he had $40,000 worth of supplies that he bought, and he didn't. He only had $4,000. Now, if it was a mathematical error, a typing error, you would probably quickly go, oh, hey, I'm sorry, it was just a mathematical error. Let me fix it. We'll go about our business. The complaint should have contain any recommended sanctions and demand for an answer. They gotta serve it. You gotta know this. It's either delivered in person, certified mail. If the certified mail comes back, then any just first class mail. That's another one they jump on every year. Okay, after that you serve them, compliance opportunity, the proceeding is not instituted until the complaint is received and until the practitioner is provided an opportunity to show or achieve compliance with all the lawful requirements. Especially it's just one expense, made a mistake, instead of $4,000, they actually typed in $40,000, nobody caught it. You want to make that right real quick. And go, oops, we're sorry, we didn't accident. You know, and maybe you can get away with that. So what happens? Okay, so the complaint respondent, you have to put it in writing. You have 30 days from the service to file an answer. You can get an extension from the administrative law judge. Remember the word administrative law judge. That's the judge that's going to oversee the complaint. He doesn't work for the IRS. He doesn't work for anybody else. Okay? So he can give you an extension. You go, I need an extension, I'm not quite ready, so you can do that. That's also, they might ask you that. What does the complaint must have? A statement of facts that constitute the ground for defense. I didn't really mean to call you that nasty word. I had taken too many pain pills because I'd gone to the dentist that day, and here's my statement from the dentist, and I just accidentally said that. I'm sorry. On the other hand, if you didn't really go to the dentist and you try to say that, and they ask you for, show me your receipt from the dentist, then you're really in trouble, because lying is even worse. Okay? So what do you got to do? You got to have a statement of facts. You got to admit or deny each thing that they ask you. They might have one problem, but they might have listed 5 or 8. You've got to admit or deny each one. Each one you don't say anything about, it's considered that you're guilty. You didn't deny it, too bad. Okay. The IRS may request for suspension or disbarment any person to provide information concerning the violation. Your client can be asked to testify against you. And what if the IRS goes, hey, you know, you could possibly be up for criminal penalties. did he tell you to do this, or did you do this on your own? Bye-bye. Bye-bye, tax practitioner. Okay. The administrative law judge can preside over a hearing. The hearing should occur within 180 days after the filing of the answer. And you can have exhibits, witnesses, expert witnesses, undisputed facts. Okay? And it must be recorded and transcribed. Testimony of witness must be taken under oath. And the administrative law judge does not have to follow the rules of evidence applied in courts. And it's sanction sought and censure or suspension of less than 6 months. It's the preponderance of the evidence. If it's a disbarment, I believe, or more than 6 months, the sanction sought is a monetary penalty, suspension of 6 months or more, or disbarment. It has to be clear and convincing evidence. It's a higher amount level. Either party can appeal. Who do they appeal to? The Secretary of the Treasury within 30 days. That's a question they ask a lot. Who do you appeal to? So the administrative law judge is the one that has the hearing, but you appeal to the Secretary of the Treasury. Everybody knows the IRS is under the U.S. Treasury Department, right? List of those receiving the assurance of notice of censure. Okay, who all gets a notice of censure or suspension or disbarment? All IRS boys, interested departments. If you're a CPA, that's going to be the CPA people. If you're an EA, EAs. Agencies of the federal government and appropriate state authorities. All those people find out. And so they put it in their list of things, and so they distribute that so you get, everybody knows about it. Censure is a public reprimand. A suspension practitioner is not allowed to practice. We've already gone over that. Disbarment, you got to wait 5 years before you can petition to go back to practice. Okay. What about renewals? So, if you're an enrolled agent, you got to be renewed every 3 years. First year, then they go by your Social Security number. So it's in 3 different years. So 1, 2, 3 is the first year, 4, 5, 6 is the second year, 7, 8, 9 is the third year. So this year, I believe, is 4, 5, and 6. So people with the last digit of their Social Security number is 4, 5, and 6. They have to renew between November 1st of 19 and January 31st of 2020. And it's effective by April 1st of 2020. You guys need to know that. It's not so important after you know it, but you got to know it. So, and so this year is 4, 5, and 6. Next year will be 7, 8, 9. I'm a 7, 8, 9.
I'm a 6.
Huh?
I'm 4, 5, and 6.
Well, but you're not an enrolled agent yet.
Oh, when?
Okay, so you're not going to have to file because until you become a enrolled agent, you don't have to do it. So what happens if you have to file? Okay, so every 3 years you have to refile and fill out the form. And what do you got to do? You got to say that you haven't been convicted of any dastardly deeds since then. Okay, so continuing education, every 3 years an enrolled agent has to get 72 hours. Okay, they have to have a minimum of 16 hours a year and 2 hours of ethics every year. If you add 16 times 3, that's only 48 hours. So you really need more like 24 hours a year to do it. But 1 year you could have 16, and the next year you could have 60, and you'd still get to your 72. As long as you have 16 every year. And 2 hours of ethics every year.
does it have to have, like, you know how IRS, you need to have so many hours of, like, federal tax law update and federal taxes too for ethics? Is the EA the same way too? Like, you have to have a certain amount under federal law update and federal tax, or it doesn't really
No.
matter?
I don't think so. I believe it's 72, 16, and 2. But in the real world, you always want to get some of those hours in federal tax update. What's the new laws? Because they change them every year. Okay, it's got to be with a qualified CE program. I'm one of their teachers. This class is not. I have chosen not to give you guys CE credit because it won't do you any good. You're not EAs yet. The only thing it would do is I get extra credit for teaching the classes, but I would only get 6 hours, and I get over 50 hours a year, so I'm not really in need of worry.
You only get 6 CPEs for teaching? Wow, that's it.
Are there other teachers like you teaching here in Hawaii?
Not teaching the EA class, but there are in other states. In fact, almost every state. Because I give the class for free, NATP doesn't really come here and try to teach it because they would want to charge you. They'd give you like 2 full days, charge you $400 or $500, and you'd have to. It wouldn't be near as good. They would go through 2 hours, 2 days of 8 hours, 16 hours. Well, 16 hours, 2 hours time, that's 8 classes. That would be part 1 for us. And they would charge you $400 or $500. Okay, you read this pretty much. The CPE has to be by a qualified sponsor. NATP Hawaii is our sponsor of this class. You can have a college can be a sponsor, an organization, NATP, licensing body, the state, the federal government. Each contact hour is equal to 50 minutes. So 2 hours for actual subject preparation. Oh, that's the teaching. 2 hours for preparation and 1 hour for 1 credit for each hour that I teach. So for tonight, I would get 6 hours. But I couldn't get any more. Each individual. How long do you need to keep all this? You need to keep it for 4 years. After you become an enrolled agent and you fill out the paperwork, you got to keep it for 4 years. Because, say, when you fill out the renewal, you will have shown them, you have to say, how many hours I got each year, how many hours I got in ethics, and I personally have all the certificates behind my copy of that form that you send in. You only send in the form. You don't have to send in the certificates. Okay, so if you go to NATP and spend 8 hours in there, you get a certificate for that 8 hours. The next day you go again, you do 8 hours and 8 hours. Now you've gotten 24 hours in 3 days. Then you go to, say, breakfast meetings and get an hour or 2 hours. You do that 2 or 3 times. So by then you've got enough for that year. Then you take a 2-hour online ethics class, or you go one of the hours. When I went to Vegas, I took 4 hours that counted as ethics. One was about earned income credit and one was about due diligence. They were ethics classes. One is the one where I argued with the lady that said she would just kick the customer. If the client doesn't have any records and he's running a business, just kick them out of your office. You know, especially for Hawaii, where we have all kinds of people from everywhere in the world with lots of different backgrounds. That's just not a nice person. And that might be for her business, because she does a lot more corporations and partnerships, and her business doesn't run on poor people. But that's my personal opinion. She probably doesn't think highly of my way of doing things either. Okay, we have identity theft. Just read that. The form down here, you need to know 14039. You'd have to fill that out if you have any identity theft. I get a couple every year.
Where's 14039?
On the bottom of page 24. Does anybody need to take a bathroom break? Go.
Oh, I'm trying to think of my hand.
The next one's gonna, it's got a lot of pages, but it's gonna be really short, because all you're gonna do, I can go over the preparers, the things for the taxpayers, but the penalties, all you gotta do is you gotta read it and memorize it. Lucky, and there's nothing I can do to help you. There will be some questions on it. Not that hard of questions. Of course, I say that because this hasn't changed in 10 years, and I read it every year and do the questions. But sometimes they ask, they're going to go, what would be a good one? Oh, here we go. Under section 6696, how many people learn the penalty sections like 6696? But they do that every now and then. So, we're going to go, when we get to the penalties, there's a lot about penalties. I can't really, you're just going to have to read it with a yellow highlighter. I'm going to hit a few of the stuff. And a lot of this stuff, you have a page of just everything. Like we just went through, remember, on what are the rules for the bad people? You know, conviction of this, conviction of that, giving false or misleading information. What were some? Disbarment. One of the things you're not supposed to do is you're not supposed to work with anybody that got disbarred or suspended. That's a big no-no. Willful failing to sign the tax return. Duh. Hopefully, if you get that as one of your questions, you will get that one. Is that okay to willfully not sign the tax return? Hopefully everybody, even if you're not a taxpayer, would get that one right. Right. The difference is willfully, not signing a tax return because they haven't paid you the money. There's nothing wrong with that. It's okay, we're got. On this one it says a tax preparer does not have to be a practitioner. Additionally, a tax preparer is subject to Circular 230 only if he or she is also a practitioner. So, those people out there doing TurboTax, signing the tax return as self-employed, they're not subject to Circular 230, but they're breaking some other laws. If they accept money for doing a tax return, you're a tax return preparer and you have to sign it. What is going to happen? Well, I'm pushing for the IRS to go after TurboTax and all the other guys and have a way to make a note of what computer that all came from. They can do this. They can tell if you've got 10 people using TurboTax from the same computer, they know this. And I would like to see them go take that person and arrest them. If they, assuming the person signs the tax return self-prepared, or go to the person that didn't go, did you prepare this tax return? Under penalty of perjury, did you prepare this tax return? And go, no, my friend did. Did you give them any money? And all of a sudden go after all that. That would change the world of a lot of fake tax information. Because a lot of this tax returns that are being done as self-prepared, they're not really self-prepared. They're just under-the-table tax preparers. Who was it today? Somebody was in there here today that their auntie had did it. Well, again, it's self-prepared. They didn't have a copy. Auntie didn't give them a copy. And so I go, well, did you pay Annie? Yeah, we paid her $140. Well, that's low by tax professional standards, possibly. But for somebody that doesn't have to worry about getting in trouble, that's not so bad. Especially if they don't have an office, don't have employees, don't have any liability, anything. Here we go. So, tax preparers. What's defining a taxpayer? A taxpayer is any person who prepares for compensation or employs one or more people. So, if you prepare a tax return in my office for me, I'm a tax preparer also and subject to the penalties. If you prepare a tax return for money, you're liable for all the penalties of preparing a tax return. You're a tax preparer. On the other hand, if you just do it for your sister, your mother, and you don't get paid anything, your mom just says, come on over, I'll cook you a good dinner. Or your friend brings you a bunch of beer. That's okay. That's not preparing tax return for money. Okay. Preparers of certain information returns are also the scope of the taxpayer. What would that be? I prepare W-2s, I prepare 1099 miscellaneouses, then I would be under the scope of the taxpayer. And if I do a bunch of phony W-2s or 1099 miscellaneouses, I could possibly have a problem. A person that does a substantial portion of a tax return who prepares for compensation or employs other people. A substantial portion. Okay? What is the definition of substantial portion? Here's insubstantial portion. I'm going to let you just primary responsibility. You guys can read this. Other than that, I can't really tell you anything you're not reading. If no compensation is provided for the person to prepare or claim the refund, the person is not a tax preparer if you do it for free. Absent of explicit, you can do it, and they can even give you a gift, return service or favor. That's not preparing it for money. Of course, if the gift is a stack of $100 bills, that would probably count. Okay, who else? A fiduciary is not a tax preparer. An employee that's doing it for the employee. We already went over this. Okay, a person who furnishes all the, who just does the typing, they're not a tax preparer. But a person who gives all the information to somebody else that all they got to do is type it in, that person is a tax preparer. So if I go in and do everything for you and just let you type it in, if I take money for it, I'm a preparer. If I do it as your friend, I'm not a preparer. and not subject to the penalties. This could be important. A tax return preparer may rely in good faith upon information furnished by the taxpayer, but they cannot remain ignorant if they hear something. If I go, yeah, I was getting really great tips when I worked at this place. I was getting $100 a night. And then you go, you look on their W-2 and they're, oh, nothing's there. Or they go, W-2, I worked there all year and it's only 20 grand, maybe 10 grand, because you get minimum wage. All the money's in the tips. Well, you got to ask questions for that kind of stuff. Okay, we sort of already gone over that. Preparer's position on the law. If you got a legal thing, you've got substantial authority for the position. Okay, so the law says you've got to have receipts to write off your expenses. And you ask the client, and the client comes in with a list from his computer that says, these are all my expenses. And you don't ask him, do you have the proof to back this up? No, of course not. I just made these numbers up, just make it easy for you. Wrong answer. Okay, preparer's position on law, basically just read all that. Substantial reasonable belief, there's, all of this is just reading. You're only going to get about 1 or 2 questions, if any, on this, but you need to know. I've already told you about errors in admission. If you find out you're doing a tax return and the taxpayer and the guy did in the past year, you have to notify the client of the error and the omission immediately. You must advise the client on the consequences of such omission. But if it was on a prior tax return, you don't have to amend it. You can tell him that he ought to amend it. You don't have to tell the IRS, and you don't have to not do his tax return. On the other hand, if that tax return that you're doing is going to be changed by what he did, my personal opinion is don't do it, or you do it the right way. And if he goes, well, that's going to let the IRS know that I cheated last year. Sucks to be you. Oh, that's probably not the right way to do that. Sorry. Okay. Taxpayer is required to sign a tax return before that is presented to the client. What does that mean? You can't send the taxpayer just the page, sign here, before you show him the tax return. That's illegal. You can't send them an 8879 in the mail before you send them the tax return. You can send them the tax return by email, by mail, by fax. Send them an 8879 or whatever. You can't really sign a tax return and send it by fax. That's not legal, right? Except if the IRS says it's okay. I just had this happen for the first time. Somebody came in. We were doing all their 4 years of their tax returns. They had to have them done by the 3rd of October. So yesterday, we were ready to e-file. We had already e-filed 16. We had 15 ready to mail. 16, 17 were ready to e-file. And the person on the line says, don't email them. Don't send them electronically. Sign them and fax them to me. So we signed them and they got a fax copy of the signature, and that is legal. Okay? I didn't know that before now. Because it's a real signature, but it's faxed to the IRS. The state of Hawaii didn't take that very well.
Oh, you faxed it to the IRS?
Yes, they said,
okay,
you have to fax it to me because this person hadn't filed their tax return for 4 years and owed a bunch of money, and the IRS wanted to get them on an installment plan, and they needed all the tax returns. And if we had electronically filed the last two, we had already filed 16. If we had electronically filed 17 and 18, they wouldn't get it in their computer for a couple of weeks, and it had to be in there by Wednesday or Thursday, I think. So it worked. I didn't know they would even let you, because that's not a real signature, that's a fax signature. But they accepted it. Okay. Original returns have been returns and requests for filing extensions that include a separate signature line for the paid preparer may be signed via computer, software program, and mechanical advice. If you ever looked on an 8879, your name, my name, and my office is already on there. I sign it anyway, but I don't have to. The person, the tax preparer, has to actually sign it. He can't be a mechanical advice, and you can't have a stamp. So a taxpayer is required to furnish a completed copy of the return or refund containing the taxpayer no later than the time is presented for a signature, right? So you got to give him a copy of the tax return right then. I had somebody tell me today that he did provide him a copy of the tax return. He actually did it over email, and now they want another copy because they're idiots, and he's no longer their preparer. But he says he doesn't have to give him another copy. I say he does, but I haven't found that in writing yet to show it to him. Have you ever heard that? You gave them the first copy, and then they come back because they lost it. You don't have to give it to them. Does anybody? I don't believe that's true.
No.
But I haven't had time to go looking for it. I think all of us are gonna be busy for this next couple of weeks. Okay, employer of a preparer. A person who employs one or more tax preparers is required to file a return setting forth the name, the identifying number, the principal place of work of each employed tax return preparer. So I have to, not only do I have to have the information about the tax return, I have to have the preparer, their identification number, P10 or Social Security number, and where they worked. That's separate list. Okay? How long do I have to keep that? I have to keep a copy of a tax return for 3 years from, I think it's July 1st at the end, starts the new year. So all the tax returns we've done, all the way up to July 1st, I have to keep those for 3 years. So any I'm doing now, it would be the next July 1st. Everybody with me on that? What do I have to keep? The name of the taxpayer's name, taxpayer's identification number, their tax years that we did, and the type of tax return prepared. 1040, 2018, the Social Security number and the name. Do I have to actually keep the tax return? The answer is no. But I have to keep all this information. It's easier if I keep the tax return. I advise everybody to keep the tax return, but under worse conditions you can do this. I don't know anybody that does it that way. But that's a test question. They've been asking that one forever.
Do you print a list for yourself, or just because you have it in your computer, you don't need the list? The list is there.
Yes, because I have it in the computer.
Okay.
Because I also take a hard drive every year from my computer, make a complete list of all the tax returns, and go take it and put it in a safe away from my place of business. I advise you guys, if you're not doing enough where you need a hard drive, you could use a thumb drive. But go make a complete list every year of all the tax returns and keep it off premises. The rule is you've got to have this, and if you don't have it, even the due diligence, well, you might be fined $2,000 a tax return. So if you did 1,000 tax returns times $2,000, that's $2 million. That could be expensive before long. Okay, while the software is largely affected, users are advised to trust the software but verify all data inputs and outputs. Have you ever heard a tax preparer say, well, that's what the software said, and the IRS says that that's not okay? You can't do that. You're responsible for what your computer prints out. I've had my employees say that to me. So, I try to teach, this is not part of this, I try to teach, when you go through a tax return and you finish it, you go over it with the client, you start off and go down it, you go, is your name spelled right? Is this your correct address? Are these your kids? Are their social security numbers? You know, maybe they got it, maybe not. Then we go down, this is your income, this is your interest, your dividend, blah, blah, just keep going down line by line. This is your earned income credit, whatever. If you do it that way, you will be in a lot less trouble. This is a personal opinion. I do it, and I try to get all my employees to do it. I'm only partially successful. But that's what you should do. Okay. If you don't have all that, I don't know if they'll even do that. You know that if you don't have a Social Security number, a W-2, you can use a 4852 for either a W-2 or a 1099-R to fill out the tax return. If you don't have the information, you're better to get the information. There's a form called the 8082. You might want to know that number. It's a notice of inconsistent treatment or administrative adjustment record. It's like if you have a K-1 and you're not following the numbers on the K-1, you have to fill that form out. I don't know if they would be that picky. It could be one of those gotcha questions though. Free software, free file software. Right now it's under $66,000. There's free file software. You go to the IRS. TurboTax has one, H&R has one, H&R Block. ATX has one. There's several others that are called Free File has one. And what they are free softwares. To an extent, TurboTax and H&R Block are a bait and switch. They get you in there and go, oh, you don't have, blah, 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 don't fit the criteria for free software. But for a few dollars more, we will fix your tax return. That's not my job to worry about it. Okay, so free file software, there's about 20 of them. I'm not going to go into it. There's not really much there for you. Okay, here we go. This is the part I'm not going to, there's nothing I can do. You've got to read this. The only way is to read it and highlight it. This is what I can do. Other than read it to you, I can't tell you much about it. We're going to go with penalties. They are in this part. They are going to do a bunch of questions about penalties. You will probably have a half a dozen. Okay? Because remember, you're going to have like 100 or 120 questions. So if you have 6 chapters, what is that, 20 questions per chapter? So, well, in this book, there's 7 chapters. But in the last course I took, it was only 6. They can divide it up. They can have 12 chapters. It doesn't matter. You're going to get a bunch of questions about penalties. So we're going to go just kind of hit it on it a little bit. So penalties, there's penalty for compliance. For not signing a tax return, not using identifying number, furnishing a copy to the taxpayer, filing a correct information return, retaining records of the copies. It's $50 or up to $26,000. Is that a penalty to the tax preparer? No, it's not. It's a penalty to the owner. If you're self-employed, it would be a penalty to you because you're the owner. Well, it says tax preparer here, but it's up above it says also subject to penalties are individuals with overall supervisory responsibility for advice given for a firm. Anyway, okay, misconduct, just read it, pretty much is self-explanatory. Accuracy-related penalties. Generally, accuracy-related penalties on a lot of our tax returns that get corrected, they put a 20% accuracy related. Do you guys get a lot of tax returns where they get letters? I'm the guy that answers letters, not just for my firm, but for a bunch of firms or people, because I do it for free or cheap. A lot of times I just do it. Even they're not our clients, just help them out, especially if English is a second language. So what happens? They get, not only they get a penalty, they gotta pay all the tax, but they get a 20% penalty, then they get an interest-related penalty, and if they filed it late, they get a late filing penalty or a late paying penalty, so they get clobbered. Okay, so penalties are 20%. The penalty is up to 40% if it's to one of the most valuation misstatements. The penalty will increase to 40% for failure to adequately disclose a transaction that lacks economic substance. You just got to read this. You're not going to get really the hard questions on this. They're going to be more common sense. Reasonable basis. Okay. If you have something that you're doing that you're not sure is okay, how do you get out of the penalties? How do you, as the preparer, get out? You disclose it. You say, I'm not sure this is okay, but I'm telling you guys this is what we're doing, and this is our reason for doing it. Then you don't have a penalty. This disclosure. When taxpayer chooses to use tax software to prepare their own returns, the tax court does not find reliance on tax preparation software to avoid an accuracy-related penalty. Again, the software made me do it is not a good answer. Negligence includes the failure to make a reasonable attempt to comply with the provisions of the Internal Revenue Service. Here we go, yeah. Substantial understatement. Substantial valuation misstatement. So you go, well, the basis in the property, my client's mother said that she bought it for 200 grand, but you don't have any proof of that. If the IRS comes back and go, whoa, she bought it for 200 grand in 1982, could you get me something to prove that? And you go back to auntie or mama or whoever, and they go, then you have a problem. If you disclose it, or they got something, now, a lot of times you guys can go on the real estate website and get a valuation for those years. That is proof. That is not guaranteed to be correct, But you did try to get the right answer. And that will probably get you out. Okay, what is the penalty for negotiating a refund check? Does everybody here know that you cannot cash somebody's refund check under any circumstances? That's a big no-no, a minimum of a $520 fine. What can you do? You can have the customer send the check to you, and you can deposit it into their bank account. That's it. You can't cash it and go, oh, I'm going to take my fees out and put the rest in there. No, nothing like any of that. The only thing you can do is just, and then after it gets deposited into their bank account, they can come take care of you. But never ever have it go through your bank account. If you have part of your business as a check cashing spot, you better have two separate businesses. You can't have it go into your account. And I know that there's out in Waianae, Nanakuli, out next to the 7-Eleven out there, there's a check cashing place that has a tax preparer sit in their office and will do your tax return, do a refund anticipation loan. You can go up to the check cashing place. They'll get you they'll print you the check, and then they'll let you cash it. They charge you about $500 for that, including tax preparation. For this is for easy tax returns. It's only double. What's it, a little money amongst friends. Okay, the due diligence requirements, we've already talked about them. $520 for your test. It's going up to $530 for 2019. The due diligence, I'm not going to go through it. You've got to know the 4 due diligence tests: completion of an 8867, submission of the 8867, knowledge, ask questions, document your questions. If you see anything that's not right, you have to ask more questions. You have to keep a record retention of this. I believe it's 3 years. Underpayment penalty, okay, so section 6694. Remember that? You're going to want to know that. And what are the rules? $1,000 to 50% of the income. Just go ahead and read that. Reasonable belief, frivolous position, willfulness. Willfulness is under section 6694. It gets higher. Fraud is 75%, and looks like willfulness is 75%. Avoidance versus evasion. Tax avoidance is sort of legal. Tax evasion, not so legal. Liability and assessment. This is mostly under 6694. But all I can do is read it to you. Liability to client. Okay, what does this mean? If you do something dastardly, you may have a liability to the client. You caused the client to get a giant penalty because you were an idiot, or you were cheating and doing something so you could get that client a great big refund, so they might give you a tip or something, and you get them a big penalty. You can be liable for that penalty. They could take you to court. Generally, it doesn't happen unless you're talking some big bucks. But if you're doing corporations and you cost that corporation $100 grand, they can afford to hire a lawyer to come after you. And then you got to hire a lawyer to defend yourself. It gets real expensive. What is the statute of limitations for understatement due to willfulness or recklessness conduct? There is none. What is the statute of limitations for fraud? There is none. A frivolous return, you need to know that. And what do they call a frivolous return? The penalties get real high. Fraud, and they've got a list of all the indicators of fraud. Omission of specific items. What does that mean? Well, I forgot that I sold that car for $20,000 profit, and I forgot that I was making money running a business for 6 months this year. Oh no. Okay. There's a whole list of income, expense deductions, indicators of fraud. What? You overstate the expenses, understate the income. These are regular old stuff. Keeping records, keeping 2 sets of books is an indicator you're committing fraud. Invoices that aren't numbered, not having invoices, not having any records. Hello. And there's a bunch of other stuff. I'm not sure how much of that. You may get something, but it's usually easy stuff. I went through the questions on these 2 chapters, and there wasn't that hard, because this is, to me, this is the same as it always is. It should be common sense. There's a few things on those pages here about like page 44, 45, 46. All you can do is read them. If you get it, understand it, great. Read it twice if not. Badge of fraud. Badges of fraud are facts that suggest fraud, but standing alone they do not establish it. Failure to keep adequate records might be something that they're doing for fraud, or it could be that the guy's just he doesn't care. Let's say another one, who would be somebody like that? Somebody working as a maid. She just works as a maid. She sometimes buys stuff, but she doesn't, goes to the grocery store and buys cleaner, but she doesn't keep her receipts. Drives her car, but she didn't keep a record of it. What do you do with a client like that? You try to do the best you can and you document what you've done. But when the client came in without any records, we tried to reconstruct as best we can.
I give them a composition book when Walmart has them on sale for 25 cents. And I say, put this right next to your seat, your passenger seat.
Well, but we've got to be careful. You got to do the best you can, or to be like that little lady that was the teacher. She wrote the book on best practices for NATP. It's a real strict book on this is the best way to do it. And you have a receipt for everything. You do everything according to down the line, blah, blah, blah. It's great. If people would only act right. Okay, here's something, things that cannot be, following type of misconduct cannot be avoided by disclosure. Negligence, disregards of regulations, a substantial understatement of the law. If you say somebody, they made $50,000 and you put down $10,000 and you know they made $50,000, disclosing, well, it may be a little low, won't get you out of that. Does that make sense? Okay, we're finally over with penalties for right now. Disclosure of taxpayer information. This is sort of the same. If you disclose taxpayer information, you can have a $250 fine. Make sure you remember that. $250 fine for disclosing taxpayer information. And it can be a lot more. So, this is 10 years ago. I had this lady come in to my office over on North King. She was livid. Okay, so she had come into one of my tax preparers, who was not the brightest bulb in the pack, and they were all friends. They were all family. So she did her tax return. The girl got a really good refund. Everything. He did the tax return greatly, but either that night or a couple nights later, the girl was at a family party, and she went to this girl's sister and go, "Your sister got this giant refund." So the girl goes to her sister and goes, "Loan me $1,000. Susie just said, well, it was Willie, something other name. Nice little Samoan girl name. Anyway, she goes, "So-and-so just told me you got," well, that lady came in my office the next few days. She was just livid, blah, blah, blah. And so I had to almost fire that girl over this. She got, I'm not sure what happened, but it was not good. Okay, so the lady could have been, she could have pushed, if she'd have called the IRS, that lady would have gotten a $250 fine, and I might have gotten a $250 fine. Even though I tell all my employees every year, do not do this, and I use this now as an example. So, okay, that's a lot of times that's a question. Okay, there's exceptions. When is it okay to disclose? If an IRS agent comes into your office and shows you a badge and says, "I want so-and-so's tax return," give it to them. It's okay. If a policeman comes in there with a gun pulled, give it to him. There's a bunch of court order, subpoenas. If another employee or partner in the office needs it for some other information, you can legally give it to them. To provide information for educational purposes. Peer review, we don't see this much. I barely even know. But about 10 years I had a guy ask me to do it. I didn't, but he wanted me to go as peer review to go through his tax returns and tell him what he's doing wrong. And I didn't want to do it. And he did get it done, and maybe it helped him, I don't know. But that is I could have legally done that and gone through his tax returns in that case, and he would not have been guilty of doing something wrong. Confidentiality privilege. Okay, I'm a tax accountant. I'm an enrolled agent.